appeal in the High Court, Al-Azad and Secretary of State for the Home Department.
Mr. Marek,
Lords,
is your
lady.
client here?
Yes. Lords and Lady, I appear for the appellant this morning with Mr. Mavrantonius.
Yes.
Milan and friend, Ms. Bottle appears for the Secretary of State.
Yes.
My Lord Justice Lewis asked the parties to provide
Yes.
certain additional documents.
Yes.
Those documents are in a supplementary bundle that is on the bench.
The black folder.
Thank you very much for that, yes.
So my lords and my lady will see that the bundle contains the 2013 application form and the relevant documents, and the 2018 application form and the relevant documents. In addition to those documents, the applications were accompanied by copies of the appellant's passport. We haven't provided those copies to the court in this bundle.
Necessary, probably.
Yeah.
So I think we've read everything. Quite
Yes.
small bundle we've read. Certainly the FTT, UT, decision letter, skeleton arguments.
Yes.
So I think we're on top of the issues.
Grateful. So can I just deal with one issue? We have housekeeping, and that concerns a question that my Lord Justice Lewis asked yesterday as to the relevant version
Yes.
of paragraph 34.
Yeah.
So,
Okay. So my Lord, if you have the authorities bundle,
yeah.
behind tab 9 you have the relevant immigration rules. It's common ground that these are the rules that were in force at the date of the appellant's application for indefinite leave to remain, and at the date of the decision, the Secretary of State's decision on that application.
Rules at 1, tab 9.
Yes,
It's common ground are the relevant rules.
yes.
Thank you.
Now, if you then look at the, if you look at the supplementary bundle, may I take my lords and my lady to the last tab. This is the supplementary bundle that was ended up.
One you just had it up.
If you go to the last tab,
So that's behind. I see. Yes.
so you'll see another version of paragraph 34.
Yeah.
Now, this is the version that is presently in force, and this is the version that was in force when the First Tier Tribunal and the Upper Tribunal decided this appeal. I meant the version of paragraph 34BB is the version that was in force at the relevant time.
Yeah, but which is the relevant version for our purposes?
Yes.
The tab 9 one or this one?
Tab 9.1. My Lord will see that my Lord, this appeal is about construction of paragraph 3221A of the immigration rules. It's not about construction of paragraph 34BB.
No.
But the reason why I've cited that provision in my skeleton is because I'm inviting the court to use that as an aid to construction of paragraph 3221A. And it is therefore appropriate for my lords and my lady to look at the both versions of paragraph 34BB. But I'll take my lords to the relevant provisions in the course of my submissions.
Thank you.
Good. So my lords and my lady, you have read the documents. This is must accept a troubling case. It is troubling both from the public interest point of view and the individual point of view. From the public interest point of view, the appellant, my lay client who is present, on the findings made below is dishonest. He has made false representations in his application for leave to remain as a Tier 1 migrant in 2013. And no part of my submissions this morning will seek to underplay his dishonesty or the seriousness of his conduct or the general desirability for his removal from this country. It is difficult, I recognize, to have any sympathy with an individual who has sought to deceive immigration authorities. But the fact that the appellant has a very difficult case to run on the facts in my respectful submission, makes it a good case to test the legal argument. This is because from the individual point of view, the appellant has resided in this country continuously and lawfully for over 15 years. The Secretary of State did not decide the 2013 application for 5 years, and the appellant varied it to an application for indefinite leave to remain in 2018. He meets the substantive requirements for indefinite leave to remain on the grounds of long residence.
Well, that's an issue because of 7276 B2, whatever it is. So that's the respondent's notice.
Yes, but so
Subject to that point.
yes, but that when I'll show you that provision, that in my respectful submission is the public interest reason to exclude someone from getting indefinite leave to remain rather than a substantive requirement. So what I meant by substantive requirement is that the appellant has 10 years continuous lawful residence in this country. That is the substantive requirement. But he's being refused on the basis of the public interest requirement on the basis of what had happened in 2013. So there are 3 issues in this appeal. The first issue is whether the First Tier Tribunal misconstrued paragraph 3221A of the immigration rules. The second issue is whether the First Tier Tribunal erred as to the 2-stage balancing exercise under paragraph 3225 of the immigration rules. And the third issue is whether the errors alleged as to paragraphs 3221A and 3225 of the immigration rules are material to the outcome. I shall seek to persuade my lords and my lady to answer these questions in the affirmative, and subject to any observations, I propose to address the court on 3 issues in turn. There is no dispute as to the facts, so I propose to focus simply on the law. So I'll start with the first issue, which concerns construction of paragraph 3221A of the immigration rules. Now, before I take my lords and my lady to the relevant rules, may I take the court to 2 authorities as to the proper approach to the construction of the immigration rules. The first authority, my lords and my lady, is the judgment of the Supreme Court in Mahad. This is behind tab 1 of the authorities bundle. And this is, in my submission, the ultimate authority as to how one should approach a question as to the construction of the immigration rules. Now, if you look at page 6 of the bundle, you'll see that the outset, you'll see that the relevant rules are quoted. So that was a case about the maintenance provisions in the immigration rules. And the issue before the Supreme Court was whether third-party sport was excluded. The rules required those who sought to settle in this country to demonstrate that they are able to maintain themselves without recourse to public funds. This court had given inconsistent judgments on the issue. One constitution had said that the third-party sport was permissible, another constitution said that it wasn't. And the issue before the court was how to read that particular provision. Paragraph 10 of Lord Brown's judgment is the paragraph where he identifies the correct approach. You have that paragraph at page 8 of the bundle. You'll see a reference to MO. This is right at the end of page 8. A reference to what Lord Hoffman said in MO, that a question as to the construction of the rule depends upon the language of the rule and construed against the relevant background. But that involves consideration of the immigration rules as a whole. And then at page 9, between letters A and C, the rules are not to be construed as they are statutes or statutory instruments, but sensibly according to natural and ordinary meaning of the words used. So this is the approach that this court will take in reading paragraph 3221A of the immigration rules. Now, Lord Brown also in this judgment identified what in my respectful submission is a helpful tool to be used in ascertaining meaning of the immigration rules. And that is the tool that I'll invite the court to deploy in this case. Now, if you go to page 13 of the bundle, and if you look at paragraph 26, this is where Lord Brown referred to certain other provisions in the immigration rules. Those rules expressly excluded third-party support. And if you then look at paragraphs 27 and 28, you'll see that Lord Brown sought to compare the rules that were in issue before the court with the other provisions in the rules, and took the view that if the Secretary of State had wanted to exclude third-party support, then that is the sort of language that the Secretary of State would have used. So it is legitimate to compare different provisions in the immigration rules in order to decide what is it that is intended. So that is Mahad. Second authority that I propose to take the court to is Pokreal. This is behind tab 2 of the bundle. In Pokreal, this court considered Mahad, and the paragraphs that are relevant are at pages 28 and 29. If you look at paragraph 42, you'll see a reference to Eddie Doyen. It's in the bundle. I will not take the court to that authority. But you'll see that the point is that in order to construe the immigration rules, it is legitimate to have regard to the Secretary of State's published policy. That, of course, won't be the case if the court is construing a statute or a statutory instrument. And then paragraph 43, there is an exception to that principle, although it is open to an appellant to rely on extraneous material in order to persuade the court or tribunal to construe the rules in his favor. It is not open to the Secretary of State to use extraneous material to persuade the court to construe the rule more partially.
What Lord, the last sentence of paragraph 42 says is that in a situation of genuine ambiguity,
Yes.
it's legitimate to derive assistance from the executive's formally published guidance.
Yes. But that, of course, won't be the case if the court is construing a statute or a statutory instrument.
Yes.
This is because, as Lord Brown said in Mahad, the rules are ultimately statements of the Secretary of State's administrative policy. So these are the two authorities on proper approach to the construction of the rules. If I may then take you to the relevant rules, they are behind tab 9 of the bundle. And again, to answer a question that my Lord Justice Lewis asked yesterday, this is the full extract of paragraph 34, as was in force at the relevant time. So paragraph 34 concerns how to make a valid application for leave to remain. And paragraph 34BB concerns multiple applications. This is at page 184 of the bundle. You'll see that the rule makes it absolutely clear that an applicant may only have one outstanding application for leave to remain at a time. The reason why the rule says so is because this is what is required by the statute, section 3C of the 1971 Act, which essentially makes it plain that a person may only have one outstanding application for leave to remain at the same time. If you look at subparagraph 2, you'll see that it says that if an application for leave to remain is submitted in the circumstances where a previous application has not been decided, it will be treated as a variation of the previous application. So there, in my respectful submission, is a clear recognition between a previous application and a new application.
There's a previous application and a variation strictly.
Yes, but the point, my lord, is that if the previous application is varied, then the previous application simply disappears. It is effectively substituted by the new application, and the Secretary of State will make a decision on that new application.
But if that's the case, what happens to the existing leave? Because under 3.3c, you've got the existing limited leave. If you apply during the currency of that leave to vary the leave for longer or for indefinite leave, your existing leave is continued.
Yes.
But if that is withdrawn or comes to an end, or there's a decision, then that's the end of it, and you're no longer lawfully here. So if somebody in 2018 brought an end to the existing application, isn't he unlawfully in this country from the date of the substitution?
Yes. The answer to that question is in section 3, subsection 5. I'll take you to that provision and the authority.
Do it when you get to it.
That is, but what subsection 5 says that although it's not, subsection 4 says that it's not open to a person to make a new application for leave to remain while an application is pending. But subsection 5 allows variation of that pending application, and variation effectively extends a person's leave to remain. So a person does not become an overstayer if the application is
The
varied.
variation, if it's a variation of the application made during the currency of an existing leave, will continue it. But you're saying this isn't a variation. You're saying there's a termination or a bringing to an end of the application made during the existing leave, and a much later application, a new application made after the end of the initial leave, is in some way going to continue leave to remain. So you'll need to think about that when you take us to 3.5, but do it when you come to it.
Yes, I will. There are two authorities on the subject as well, but I'll answer that question by reference to the two authorities. But what the reason why I'm showing the code paragraph 34BB is because it uses expressly the word a previous application. And what in due course I'll invite the court to do is to compare the language in this rule with the language that is used in paragraph 3221A.
I mean, it doesn't say a replacement for the previous application. It says a variation of the previous application.
Yes. But the point, my lord, is that where the Secretary of State intends to refer to a previous application, he says so. He says so in these terms. Now, if you then look at the next page, page 185, and you'll see a heading 34, just above Rule 34E, variation of the applications or claim. Now you'll see that this may assist in relation to the question, my lord, that my lord Justice Lewis asked, that where a person wishes to vary the purpose of an application, the variation must comply with the requirements of Rule 34, i.e. it must be made on a relevant application form, fee must be paid, but the variation will be treated as a new application.
Where does it say that? Sorry.
Yes, it's Rule 34E.
Where does
The
it say?
variation must comply with the requirements of paragraph 34 as if the variation were a new application.
It is.
So where a
That
person,
rather underlines the fact that it's not,
Yes.
because you need the fiction as if it were a new application. I read that to mean because it's not a new application, it's a variation of an existing application.
lady, I have no difficulty with that analysis. That will not undermine the primary submission that I'm seeking to make. I mean, the reason again I'm seeking to cite these rules is that the Secretary of State has used the words previous application and a new application. And the reason I'm highlighting these rules is that, well, this is the sort of language that one expects the Secretary of State to use if the Secretary of State intends to refer to a previous application. And then 34F, that any valid variation of leave to remain will be decided in accordance with immigration rules in force at the date of such at the date such variation is made. Now, if you then go to page 187 of the bundle, you'll see a heading long residence, and under that heading,
Sorry, I've lost my place. Where are we?
yes, page 187, tab 9 of the bundle. The long residence rules and see that it is a lengthy provision, but if you wish to see the precise requirements, they are at page 190 of the bundle, under the heading Requirements for Indefinite Leave to Remain on the Grounds of Long Residence.
Yes.
You'll see that the first requirement is that the appellant must have at least 10 years continuous lawful residence. And then subparagraph 2 is the public interest provision.
I mean, although you say it's a public interest provision, it is one of the requirements. It's not like 322 and a refusal. You qualify, but you're refused. It is part of the requirement that you meet the public interest requirement as to personal history, including character, conduct, and association.
Yes, it is.
It's
It
an
is one.
eligibility requirement.
Yes, that is indeed the case. So, but if there is, but you'll see how the rule is expressed. It's expressed in the negative. So if a person has 10 years continuous lawful residence, the Secretary of State then moves on and consider subparagraph 2 and sees whether there is a reason that would make it undesirable for him to be given indefinite leave to remain. It is, except one of the requirements that an appellant must meet, but it is the public interest provision.
It's not tied to the date of the application is the point. It's tied to the personal history. And even if you're looking at long history or long residence, truly it's personal history as a minimum during that 10-year period.
Absolutely, I accept that, yes. So it's open to the Secretary of State to refuse an application for indefinite leave to remain on the basis that a person had used deception 10 years ago. But what this sub-rule requires is a balancing exercise. That is the second issue. Now, if you then look at the next page, page 191, you'll see sub-rule 3, which says that the applicant does not fall for refusal under the general grounds for refusal. And those are the grounds under Part 9 of the immigration rules, which includes paragraph 3221A and 3225. So this is paragraph 276B. If you go to page 192, you'll see the general grounds of refusal. You'll see a heading at page 192, refusal of leave to remain, variation of leave to enter or remain, or curtailment of leave. And you'll see paragraph 322 there. And you'll then see another heading, grounds on which leave to remain or variation of leave to enter or remain in the United Kingdom are to be refused. So these are the mandatory provisions. If you fall within that paragraph, the Secretary of State has no discretion under the immigration rules. The Secretary of State must refuse the application. And then you have Rule 1A, the rule that the court is concerned with, where false representations have been made or false documents or information have been submitted, whether or not material to the application and whether or not to the applicant's knowledge, or material facts have not been disclosed in relation to the application. So the short submission, my lords and lady, is that this is the application that the Secretary of State is deciding, not a previous application. There is a good policy reason for that distinction. And once I've shown you the rules, I'll take you to the Secretary of State's policy and explain what is the policy reason behind that.
Can we just pause this paragraph for me?
Yes.
So, does the last part of it, i.e. the section headed beginning with words in relation to the application,
Yes.
qualify the whole of the rest of the previous paragraph, whole of the paragraph, or just the words all material facts have not been disclosed?
Whole of the paragraph.
Okay.
What about the second line, that where false representations have been made or false documents or information have been submitted, whether or not material to the application. So even assuming you were right, it meant the current application, not an earlier varied application, if false representations have been made, whether or not material to the application, it's a basis for refusal.
Yes, if false representations are made in the fresh, varied application, then.
So it doesn't matter if they're not material to the application, but they must relate to the application.
Yes, so for example, if there is a question in the application form as to whether an applicant is married, that applicant is married and it ticks that he's single, that may not be material to the application, but it is a false representation, and the Secretary of State is entitled to refuse that application. A more realistic example would be an applicant submitting a false document with an application that he need not to submit. For example, an educational certificate that is false, that is not relevant to the application or the criteria. I mean, for instance, if an applicant is making an application for indefinite leave to remain on the grounds of long residence, and with that application he submits a fraudulent educational certificate.
So the document would not be material,
Yes.
but would have been filed in relation to.
Yes. And there is a good policy reason for that, which is that if false representation is made in the present application, that's enough for the refusal of that application. So it's the application, not the previous application or any application. So what the tribunals below have done in my respectful submission is to read the phrase "the application" as any application or the previous application. Now, my Lords, my Lady may then ask as to what are the Secretary of State's options if deception was in a previous application. The options are in paragraph 3222 of the immigration rules, which is on the next page, page 193. Now you'll see at page 193 a heading, grounds on which leave to remain and variation of leave to enter or remain in the United Kingdom should normally be refused. So these are the discretionary grounds.
Yes.
You'll see that subparagraph 2 refers to making a false representation for the purpose of obtaining leave to enter or a previous variation of leave. So if there was deception or false representation in a previous application, the policy is that would not result in an automatic or mandatory refusal. The Secretary of State would want to know what had happened following that deception.
But the variation there is not the variation of an application, but the variation of leave.
Yes, for the purpose of previous variation of leave. So variation of leave essentially is when a person makes an application for further leave to remain, that is variation of that leave. So if for the purpose of that application, a person makes false representation, that application is mandatorily refused. The person then stays on in the United Kingdom for years. The circumstances change. He then puts in a new application for leave to remain. The Secretary of State will not automatically refuse that application, but will exercise discretion, look at all the circumstances holistically, and then decide what to do.
But leave hadn't been granted in this case at the material time. Had it?
In this case, the appellant's residence was throughout continuous and lawful.
Well, he arrived on a student visa,
Yeah.
and I think he made 2 applications which were granted for an extension of limited leave. So those applications were made and decided. And if there had been fraud in relation to those 2 applications, paragraph 3222 would have arisen. The problem that we've got here is that this is an application initially, on one view, as a tier 1 entrepreneur migrant. And the question is, was that application varied? Or,
Yes.
as you say, did it simply cease to exist?
Yes, that is the issue. Now, you have paragraph 3221 and 3222, and you'll see the difference in the language and the approach. And the reason, in my respectful submission, why there is this distinction is obvious. So when, for example, a person makes a tier 1 application, submits a false document, it is understandable why the Secretary of State would refuse that application on mandatory grounds. But if following that refusal, a person stays on in the United Kingdom, or if there is no refusal, and a person then varies that application to a different kind of application, in this instance, an application for indefinite leave to remain on the grounds of long residence, it could be an application for leave to remain as a spouse of a British citizen, or as a parent of a settled child. It is, in my respectful submission, understandable why the Secretary of State would then not refuse that application on mandatory grounds.
But have the right to do it on
Has
voluntary.
the right to do it, yes. So the Secretary of State will consider the circumstances holistically, welfare of a child, interests, the rights of a British citizen spouse, and will then decide how to exercise discretion.
And it used in your case, if there, insofar as there's any ambiguity in this, it should be, you should interpret it in your client's favour, following authority.
Yes, in the light of the Secretary of State's policy, to which I'll take you to now. And then, so that we won't have to come back to these rules, if you look at subparagraph 5, you'll see that this is somewhat similar to paragraph 276b Roman 2. It allows the Secretary of State to refuse an application on the basis of undesirability of permitting a person to remain in the United Kingdom on account of his conduct, character, and association. And this is yet another provision that the Secretary of State may use if there was historic deception. Now, the Secretary of State's policy is behind tab 10 of the bundle, and this policy concerns false representations. And if you go to the last page of this document, page 206, you'll see a heading, false representation in a previous application. If the false representations were found to have been made by the applicant in relation to a previous application, a current application for entry clearance must be refused.
That doesn't really help, does it? That says if it is a previous application, but the question here is whether you're right on construction,
Yes.
and whether this is a previous application or one application which has been varied. So it tells us what the consequence is, but it doesn't help us to decide which interpretation is correct.
Yes, but what it, in my respectful submission, assists, it assists in this way that there is, the Secretary of State has used the word a previous application, that the same word that he
It
used
appears in
Yeah.
34
34 BB.
BB.
Yes. So the word, the phrase previous application in the policy, in my respectful submission, must be construed consistently with Rule 34 BB. But you'll see the distinction in that paragraph. So if there is previous deception, then the entry clearance must be refused. So if a person leaves the country, makes an application, the entry clearance must be refused. And a current application for leave to remain should normally be refused. So distinction, if there is an in-country application, the Secretary of State will exercise discretion. If it's an out-of-country application, it's a mandatory refusal. There are separate rules for entry clearance applications and a mandatory ban. So this is the Secretary of State's policy. Can I then just show you the current version of Rule 34? You have that in the supplementary bundle, the black one we got this morning. Now, if you look at, this is the last tab in the black bundle. And if you look at Rule 34BB, now this is the provision that was enforced when the tribunals made the decision. But you will see that the rule has changed slightly. It makes no material difference to the argument. But you will see that is now a reference to the previous application and any further application. And then a most recent application. So again, a clear distinction in my respectful submission between the original application and the application that is varied is referred as the further application or the most recent application.
So how do you say that interpretation fits with your interpretation of the previous version?
Well, again, the Secretary of State has used the phrases previous application, any further application, or the most recent application. Now, this is, if the intention of Rule 3221A was to catch deception in previous applications, then this is the sort of language one would have expected the Secretary of State to have used. Secretary of State would have said in Rule 3221A that if false representations are made in any application or in a previous application, then that would result in mandatory refusal of leave to remain. But Rule 3221A refers to the application, nothing more than that.
I understand they use the word the previous application, but it has a definition section. And what they're saying, if you look at it, or one analysis is, where the application is an outstanding application for entry clearance or permission to stay, which has not been decided, that is this case. An application was made on the June 2013 and it hasn't been decided. And that's called the previous application.
Yes.
Any further application for entry clearance or permission to stay, that's the December 2018 changing the basis and the duration.
Yes.
And what's the status of that piece of paper with the word application on? And the answer is, it will be treated as an application to vary the previous application. So its legal status is to be treated under the rules not as a fresh, separate application, bringing to an end the previous application. It varies the previous application, is how the rules look at it.
And then if you read on, my lord, the provision
And the most recent application,
will be considered. So
Yeah.
that is the 2018 application.
but when it's considered as an application, as a varied application, if you read the earlier words. Can you really say that they're two separate legal things, given that the middle bit says they're going to be treated as a variation the one of the other? They're clearly two separate documents, and they each have different dates and the word application on them somewhere. But what this is saying in the middle is that the later is treated as a variation of the earlier, so that there isn't a bringing about of the end of the first undecided application. It's just switching the basis on which it's going to be considered.
Yes, but the original application that is varied in my respectful submission simply disappears. That is the effect of the words that only the most recent application will be considered. And that is the reason why the Secretary of State has not made a decision on the Tier 1, application.
So it's not brought to an end, it just merges, if you like, you'd say, with the later decision. It becomes redundant effectively, it doesn't need to be
No,
done.
you don't say that, I don't think, do you?
No,
How would you put it?
I say that application simply disappears.
Falls away.
Cause where?
Yes. Yes, and it's the new application that the Secretary of State will decide. And if there is deception in that original application, the Secretary of State may refuse the new application
Discretion.
on discretionary grounds. But what the Secretary of State cannot do, in my submission, is to refuse the application on mandatory grounds. That the reason being obvious, the circumstances may change. There is now 10 years continuous lawful residence, marriage to a British citizen, a child, for example.
I mean, it would have been open to the draftsman of the new version to have excluded the words, the middle part of the paragraph, wouldn't it? Because in your case, it doesn't matter that it's an application to vary.
Yes, it
It's
does.
just a new it falls away.
The original application falls away, yes.
But it doesn't say that.
Well,
It says it will be treated as an application to vary the previous application.
Yes, the reason why I say it falls away is because of the concluding words in that rule. Only the most recent application will be considered, which effectively means that the original application will not be considered. And that is why the Secretary of State has not considered the Tier 1 application, has not refused, has not made a decision on the Tier 1 application.
But he wouldn't have needed to if it had been varied, or whether it had been disappeared. Whether it's varied or disappeared, that's not the reason why he hasn't considered it. Initially, your client wanted to be granted leave to remain on the basis that he was an entrepreneur.
Yes.
He can't on any analysis get that because that was a false application.
Yes.
So he's not going to get Tier 1. So the question is that refused? The answer doesn't need to be refused on that basis because the basis on which he was seeking leave became ultimately 10 years residence.
Yes. I'm not complaining, my lord, that there isn't a decision on the Tier 1 application. I'm simply
It's not because it's disappeared, it's because the basis that he's seeking
has
to
changed.
remain has changed.
Should we just look? I mean, and of course, we're in the new version. Let's bear that in mind. Maybe we need to look at the original version. But do the following sub-paragraphs of 34B help us with the interpretation of 34.BB1?
Yes, I mean, for instance, if you look at subparagraph 3, so any valid variation to vary a previous application will be decided in accordance with the immigration rules in force at the date the application to vary is made. There is an authority on that. I'll take you to that in a minute. But
Is that what's the equivalent in the previous rules, the ones that were enforced at the relevant time of the application?
um,
34E, is
I
it?
guess 34E. And then perhaps sub-rule 5, where more than one.
Or actually,
Yes.
where an application to vary a previous application has been made, and we're told that's how the new application is being treated, the Secretary of State will contact the applicant to notify them that the application, that must be the new document,
Yes.
is being treated as an application to vary, and that any previous application will have been varied, not will cease to be.
Well, yes. So when the application is the submission, my lord, is that any decision will relate to the application as varied, which I say is the further application or the most recent application, just using the words in subparagraph 1.
But it seems to presuppose that the previous application continues to exist and will need to be determined, therefore. It's just that it's been varied. If, in fact, the result of the second document is that the earlier document has come to an end and disappeared, then it wouldn't be any previous application would have been varied. It would have been the previous application which is now defunct.
Well, Lord, one needs to read subparagraph 4 with subparagraph 5 and 6. So if you look at 6, for example, the Secretary of State asks the applicant to provide a confirmation. If the applicant does not provide a confirmation within 14 days, the most recent application will be considered, and any other applications will be treated as varied, unless it's not clear which is the most recent application. So the application I accept is varied, but the analysis that I respectfully invite the court to accept is that the decision will be on the application as varied. And if there is deception in the varied application, that will result in automatic refusal. If there is deception in the original application, the Secretary of State may refuse that application on discretionary grounds, but not on mandatory grounds.
Has paragraph 34BB1 of the earlier version survived into the new version? The assertion that you can only have one application outstanding at any one time.
Yes, because if you look at subparagraph 1 of the current version, the concluding words, and only the most recent application will be considered. That, in my respective submission, has the same effect, namely that a person can only have one outstanding application at a time.
So the whole thing, having previously been under the heading multiple applications, is now all folded into the section headed variation.
Yes. Yes. Yes, so, but the rules, as said, it's common ground. The relevant rules for our purpose are the rules in the authorities bundle
Yeah.
about multiple applications. So these are the rules. There's two authorities that, in my respective submission, provide support to the construction that I seek to put forward. They are not, I confess, on construction of the rules, but the two authorities are on construction of Section 3C of the 1971 Act.
Are you going to go to 3C before you go to the authorities? We do need to consider 3C, because if you're right, there's a major problem for many other people seeking leave to remain, or are we not going to look at Section 3?
Yes. No, can I take you to Section 3C? It's
In the
referred in one of
judgment,
the
yeah.
authorities. And
Yeah.
if you look at the authorities bundle, tab 4, you have the judgment of this court in
Zimbabwe.
Zimbabwe.
And so we don't have to go, you say, to the statute itself, we can just find it from this authority.
Yes, so this Section 3C is quoted in full in this judgment at page 67. So this provision applies where a person has limited leave to remain. He makes an application for variation of that leave. The leave expires. The application is extended while the application for variation is neither decided nor withdrawn, or an appeal is pending. Look at subsection 4. It says that a person may not make an application for variation of his leave to enter or remain in the United Kingdom while that leave is extended by virtue of this section. So if a person has made an in-time application for leave to remain, the leave expires, a person may not make an application for variation of that leave. But what is allowed, this is subsection 5, but subsection 4 does not prevent variation of the application mentioned in subsection 1A.
So putting it into this case, he had an existing leave. Before that expired, he made the application in 2013.
Yes.
Because that hadn't been decided or withdrawn, the 2013 application, it continued. He can't make any further application, any new, different, fresh application,
Yes.
because if he does, he risks losing his leave.
Yes.
But what he can do is vary
That application.
the 2013 application.
Yes. And
If you're right and the 2013 application is now deceased, how does it fit into 2A? It's either decided or withdrawn. Has it been impliedly withdrawn by the making of the later application?
no, it's not. It's not withdrawn. Lord, may I take you to a paragraph in that judgment which may deal with precisely that question, and that is paragraph 35.
Yep.
This is where the court summarized the effect of section 3C in a succinct paragraph, and the answer may be in the last 3 sentences. There can be only one application for variation of original leave, and there can only be one decision and one appeal. The possibility of series of further applications leading to an indefinite extension is excluded. However, this is the last 4 lines, by subsection 5, it is possible to vary one permitted application if it is varied, any decision will relate to the application as varied.
That seems to be against you, because that seems to be saying the 2018 application varies the 2013 application,
Yes.
and the decision will relate to the 2013 application
Yes.
as varied.
Yes. So yes. So this the submission is that on analysis in my submission supports the appellant's position, because the decision that the Secretary of State will make will be on the varied application, the 2018
The
application.
varied application, it's still the 2013 application, albeit varied.
Yes.
It's not a separate new application as a matter of law.
Yes, but the decision will be on that varied application, not the original application.
Yeah.
And hence I respectfully submit that that if the decision relates to the varied application, then the focus must be on that application. If there is deception in the varied application, the Secretary of State must refuse that application. But if the deception is not in the varied application, but in the earlier original application, then
Discretion rights.
then the discretion. That is the submission. The decision will relate to the application as varied. The decision will not relate to the original application.
You could reach that result without going to 34BB. You could simply say that application in 322 means the application is varied, and the mandatory grounds apply to the application is varied. You hardly need to go through having two separate legal applications, and you've got a real problem, because if by making that application in November 2018, the initial application came to an end and no longer had to be determined, his extended leave, the first leave that he's got that's being kept alive by Section 3C, something's got to happen to that. And the section only contemplates withdrawal or decision. You're saying there can't be a decision because it's disappeared.
Yes.
Well, the only thing that it could be is withdrawn, i.e. not something that is there anymore. But if it's withdrawn, as from November 2018, he was unlawfully in this country.
Yes, but it's not withdrawn. It's not withdrawn. It's not decided. In my submission, it simply disappears. It falls away.
What is it? If it's
So it simply it's no longer pursued. Circumstances has changed. The application is varied, and the Secretary of State will make a decision on the application as it is varied.
Am I right that what 3C is designed to do, the purpose of 3C, or a purpose of 3C, is to prevent unending applications to vary? You can apply to vary once,
Yes.
and the extension of the leave provisions in 3C will then apply.
Yes.
But you can't keep on applying
No.
to vary.
So there's one permitted application. You can vary it once. If you vary that application, the submission is that the Secretary of State will focus on the application as varied and will make a decision on that application.
No, what this is designed to do, if you apply on one thing, I'm a student, next time you say, no, I'm now going to be an entrepreneur. Next day, you're going to put something else in. The Secretary says, I'm not going to decide on all those different things. I'm not going to decide if you're a student, if you're an entrepreneur, or whatever. You've got one application, that's the one that you made during the currency of your existing leave. If you want different grounds from the one that's put in that application, all that will happen is I'll treat your most recent expression of the grounds upon which you know which leave remain as the application, the varied application. So it's to stop constant requests on different
And
bases.
constant extensions.
Yes, that is the purpose of Section 3C and the purpose of the rules. I accept that, but that does not defeat the argument that I'm seeking to pursue. That once an application is varied, then and if there is deception on that application, it cannot be refused on mandatory grounds. And that I'll give the example again. I mean, if to say that a varied application can be refused on mandatory grounds if there is historic deception, will lead to some extraordinary consequences. I gave an example of a person using deception in a Tier 1 application or a student application. The application is not decided for many years. In the meantime, he settles in this country. There's now a British citizen wife, a British citizen child. to say that, and the application is varied, to say that that varied application on a different basis must be refused on the basis of historic deception, in my respectful submission, would be an extraordinary consequence.
Well, that's your argument, isn't it? That's the principal point.
Yes.
Yes.
The Secretary of State has a discretion, but not an obligation.
Right.
Taking the example of this case, the 2013, the Secretary of State could have refused the 2013 application in 2013 or in 2014 on the basis of deception. But then now the appellant has lived here for 15 years. The submission is that it would be extraordinary for the Secretary of State to say that, well, I'm going to refuse your application no matter what, irrespective of your long residence, your human rights, or family circumstances, because of the previous deception. So the submission is that as a matter of common sense and policy, the Secretary of State will need to consider things holistically, exercise a discretion. He may still refuse the application, but not on mandatory grounds.
Okay. You were going to take us to another authority.
Yes,
I
that's
think.
the
If we
final
finish with
authority.
JH.
That is the judgment in Khan, which is behind tab 5 of the bundle. Now this was a case where a student made an application for leave to remain as a student. Now, while the application is pending, his college lost the license. He then enrolls at a different college and varies the original application. The Secretary of State refuses the varied application on the basis that the maintenance provisions are not met. Under the maintenance provision, the applicant was required to have specific level of funds in the account as at the date of the application. And the Secretary of State used the date of the varied application as the relevant date. And on that date, the funds were not in the account. But the funds were in the account on the date of the original application. The appellant argued that, well, it is the sort of analysis that Lord Justice Lewis is contemplating, that, well, it is really the original application that counts. That is the
The
application.
difference is the original application and the dates during the currency of that application at which various requirements must be met. There are arguably two different things.
Yes, but the point was that, well, it is the original application that really counts. And what the Secretary of State should do is to look at the date of the original application, because the second application was not a new application, it was merely a variation of the new application. And if the funds were there at the date of the original application, which there were, the appellant succeeds. He was successful in the tribunals, but this court disagreed. And the
Another
reason,
argument from the Treasury, from the Secretary of State.
yeah, so
I see.
yeah, so if you look at paragraphs 5 and 6,
Yeah.
You'll see that Rule 34E is quoted, and it's really paragraph 50.
Or
where-
5.
Interesting, 34E says the variation must comply. It doesn't use the words the application at all, does it?
Yes, so yeah, and that was picked by Lord Justice Beatson at paragraph 50. It is clear that it's concerned with a variation of application and the form that there must be compliance with the requirements as they apply at the date of the variation, as if the variation were a new application or claim. And the court essentially said that, well, it's really the date of variation that counts.
Yes.
You got to have funds in that account, in the account on that day. So variation is effectively being treated as a new application or claim, essentially.
But is the one that my Lady Justice Whipple said, the very fact you've got to make a fiction as if the variation were a new application or claim, rather suggests that it's not a new claim, it's a variation. And you've got to tinker with the rules and create a fiction to make the later date requirement, make the requirements apply to a later date.
Yes, but so that in my respective submission does not undermine my argument, whether it's a new application or is being treated as a new application. The point is that the Secretary of State will make a decision on the new application or the varied application, looking at the circumstances as at the date of the variation, applying the rules as at the date of the variation, as opposed to the original application. So ultimately, in my respective submission, this issue comes down to the meaning of the phrase "the application" in paragraph 3221A of the immigration rules. You compare that word with that phrase with the phrase that is used in paragraph 3222, which refers to previous application. It becomes, in my respective submission, clear that the scheme is that if there is deception in a previous application, it's discretionary refusal. If deception is in the current application, it's mandatory refusal. So the submission that I seek to put forward in my respective submission is consistent with the language of the rules read as a whole. It is consistent with the principle, and it's consistent with the authority. Now, can I then just show you what the tribunals said as to that provision? You have the First Tier Tribunal's decision in the appeal bundle at page 101. And can I take you to page 116, where there is a discussion as to paragraph 3221A. And there is a heading just above paragraph 81, 3221A. But what is immediately clear from paragraph 83 is that the judge was not assisted. No one provided any real submissions on the interpretation of the relevant rules. The relevant authorities were not brought to the judge's attention. The judge accepts that at paragraph 83. And then there's a reference to JH Zimbabwe, that there may only be one application at a time until it is decided. It is of course true, but what JH Zimbabwe also says is that the decision will be on the varied application. Paragraph 85, the judge says that, well, the application remains that was originally made. That is the application. You have my submission as to that. The judge, not his fault, has not compared the rules that I've sort of highlighted in my submissions. And then paragraph 86, the judge says that, well, there is no good policy reason why the Secretary of State would have distinguished between the applications in that way. There is a good policy reason that I've highlighted. There is the final point the judge made is at paragraph 88. The judge says that, well, Rule 3222 does not really apply. It is not clear whether that rule would actually apply because the judge says at paragraph 89 that the 2013 application did not lead the appellant obtaining variation of leave. And the judge understandably says that, well, if paragraph 3222 does not apply, then it's got to be paragraph 3221A that applies. The problem with the judge's analysis at paragraph 89 is that it completely misses the phrase "for the purpose of" in paragraph 322. So it's not necessary for an appellant to obtain leave to remain for there to be a discretionary refusal. If a person seeks to deceive the Secretary of State for the purpose of making a previous application, then that's enough for the Secretary of State to refuse the application on discretionary grounds. Now, when the matter came before the Upper Tribunal,
he does say, to be fair, before we leave, that if he was wrong about that, he did conclude that the discretion, and it was the 3225 case, and that was a second basis that the Secretary of State gave. He
Absolutely.
does say that he would have accepted the
That's your-
3225, but you've got a second
That's your
ground
second,
about that. Yeah.
second issue. You're coming on to that.
Of course. Yes.
So we go to the UT next, do we?
Yes. Just to show you what the Upper Tribunal said as to this particular point.
You were here by then.
Yes. Page 73. I think that the Upper Tribunal did not say that there is that the judge has got in my submission did not agree with the First Tier Tribunal's decision. If you look at paragraph 46, the judge in the Upper Tribunal said that the error was not material, as opposed to saying that there was no error. In my submission, the error in the First Tier Tribunal's decision is clear. But the judge said that, well, this error is not material because the judge in the first year said that other suitability provisions were engaged. And the point is academic.
So you say he doesn't really pronounce on your submission?
Yes. Yes, but yes. He said that, well,
Irrelevant,
the
academic.
point does not arise, but surely it arises because the refusal under 3221A is mandatory. The refusal under 3222 and 3225 is discretionary, and so is paragraph 276B2. And there is a difference. There's a difference between the two provisions. If I'm wrong about the first point, that really is the end of the appeal.
Yeah, because even though you didn't deal with it, you'd have had to refuse the appeal. But if you're right on 3221A, then you've got to consider whether he's been treated. He said it's going to be refused as a matter of discretion anyway, so why worry about mandatory? But if he was wrong in his analysis of why it would be refused on the discretionary ground, then you do need a 3221A decision.
Yes.
And if he, in citing your submission, he cited the current rule, not the previous rule.
Yes, the versions that were in force as at the date of the hearing at the First Tier Tribunal and at the Upper Tribunal.
Did you draw attention to the rules that were in force at the time that the decision was made?
No, I must confess. It's just that this provision changes on a sort of monthly basis. So the two versions that I've shown you are not the only two versions. There have been many changes in between, but what I think we ultimately decided was to show you the two versions that were really relevant as at the date of the application and the date of the hearing.
So we don't really get any assistance from the Upper Tribunal's treatment of this issue.
No. So these are my submissions on the first issue. So I'll move on to the second issue now, paragraph 3225. So you have seen that provision in the immigration rules. What I will do is to take you to two authorities on that provision, and we'll then just make very brief submissions on the facts. So the first authority is the judgment of this court in Balaji Gari. Well, this was the test, the lead case on paragraph 3225 of the immigration rules, provision that we are concerned with. And if you look at page 102 of the bundle, you'll see a heading just above paragraph 33, the correct approach. And under that heading, Lord Sandhill identified the correct approach, essentially a two-stage approach. The first stage is dealt with from paragraph 34 onwards. You'll see a heading, the first stage, undesirability. So what the Secretary of State must do is to take proper account of all relevant circumstances known about the applicant at the date of the decision, of whether his or her presence in the UK is undesirable. And this should include evidence of positive features of their character. If a person has used deception once, but there is other evidence of his good character, then that is also relevant, because ultimately the Secretary of State has to make a judgment as to the undesirability of a person's presence in the UK. Now, if you go to paragraph 38, this is where this is still the first stage. And at first stage, the decision maker is required to conduct a balancing exercise, paragraph 38, between E and F, informed by weighing all relevant factors. And that would include such matters as any substantial positive contributions to the UK made by the applicant, and although the circumstances relating to the misconduct in question, e.g. that it occurred a long time ago, as the court may know, the immigration rules generally specify a 10-year time limit when it comes to breaches of the immigration laws or deception, or if there is deportation. For example, if a person uses deception, then if he leaves the country, he faces a 10 years mandatory ban. So what Lord Justice Hill was seeking to say is that, well, a deception is relevant, but it is also relevant as to how long it took place. If it took place 10 years ago, serious though it is, one has to look at what has happened over the period of 10 years. So that is the first stage of the balancing exercise.
Just pause there. What he's doing in paragraph 38, as I read it, is reciting Mr. Biggs's submission about what ought to happen. But at G, he says, while we would not say that it would always be an error of the law for a decision maker to fail to conduct the balancing exercise explicitly, we agree that it would be good practice for the Secretary of State to incorporate it in the formal decision-making process. So the submission is not accepted completely.
Yes, lady. Well, yes. Yes. The next authority that I'll take you to, where Balaji Gari was considered, essentially holds that that the decision makers must conduct a balancing exercise.
Okay.
But that is paragraph 38. And then the second stage is at paragraph 39. And so once the Secretary of State has decided that it's undesirable to allow a person to remain in the UK, there is then another discretion, because 3225 itself is discretionary. It says that an application should normally be refused. And at the second stage, one has to consider welfare of any minor children, any human rights issues, and other ancillary matters. This will include a person's length of residence in the UK, the private life that he has established, and so on. So this is Balaji Gari and the two-stage balancing exercise. The next authority where Balaji Gari was considered is Yasin. You have that behind tab 7 of the bundle. Now, Yasin was a case where the tribunals made a finding of misconduct and dismissed the appeal for that reason. There was an appeal to this court on the basis that it was mandatory for the tribunals to conduct a balancing exercise, that the two-stage balancing exercise, and the failure to do so makes the decision wrong in law. That is the point that Milady, the point that is troubling Milady. If I may just take you to paragraph 46 of the judgment, last paragraph. You see that paragraph 46, the court took the view that in all but most extreme cases where the conduct complained of is such that on any view the balance must fall against an applicant, even where a sufficient character or conduct issue is proved, a balancing exercise is required. The most extreme case, in my respectful submission, would not be a paradigm case of deception, but a case, for example, involving serious criminal offending, or where a person, for example, comes to this country as a visitor and makes an application within a month or so on human rights grounds. So that would be an extreme case where it would be obvious that there is no possibility of a different outcome.
Can I just check how the balancing exercise works? Because on one reading, it seems to be three. You've got the question of whatever the rules say in 325. You've got undesirability and you've got circumstances which, notwithstanding the conduct leading to undesirability, the discretion shouldn't be exercised. And it's not clear to me which factors go to undesirability, or whether you look at undesirability by reference to the conduct and then you say, well, notwithstanding that reprehensible conduct, nonetheless, the contribution to society and the lengthy payment of taxes and working here outweighs that. So I'm wondering whether it's permissible to say, that's pretty bad conduct. Okay, I know he's been here a long time and it was a long time ago. It still doesn't outweigh it. Or whether when you're deciding whether or not it's sufficiently bad conduct, you must look at those factors. And I was just looking at 3225.
Yes.
The undesirability of permitting the person concerned to remain in the light of his conduct, character, or associations.
So when the Secretary of State is making an assessment as to undesirability and looking at a person's conduct, then the Secretary of State or the decision maker will look at the conduct as a whole over the period of 15 years, as opposed to the conduct in relation to one application. So this is the first stage where the Secretary of State is considering conduct and undesirability. Of course, the Secretary of State will start with the deception, but will then look at, for example, if a person has used deception in one application, but has then acted honestly otherwise, and has made sort of positive contributions in the country, worked for different charities, providing public service, for example, demonstrating that he is a person of good character otherwise, then a decision maker may take the view that notwithstanding that deception, it is not undesirable for that person to be given leave to remain.
But the Secretary of State in this case decided that it was a sufficiently serious case to fall within
Yes.
the category identified by Lord Justice Irwin in paragraph 46 of the Asylum.
Yes. So
The FTT upheld that.
yes. So yeah, that is the submission. Of course, is that the First Tier Tribunal did not follow this approach. There wasn't any real balancing exercise. Well, these are the principles that I'll take you to that decision. Now, can I just say this for completeness, that Balaji Gari was a case simply on paragraph 3225 of the rules. Yasin was a case about paragraph 3225 and paragraph 276b, subparagraph 2, which essentially has the same import. Both are about the public interest considerations. So that is Yasin and Balaji Gari. So if I may now take you to the First Tier Tribunal's decision and just
Should we start with the decision letter? Just have a look at that.
Yes, but this is, yes, I'll take you to that decision. But because this is a sort of statutory appeal, the focus is not on the Secretary of State's decision. The tribunal is the primary decision maker.
I appreciate that.
I'll
It would
take-
be helpful just to look at
Yes.
how the decision maker treated it.
The reasons are of the tribunal are sent to an informed decision, to an informed reader, and to be the decision of the tribunal to be read against the background, aren't they? The Secretary of State's letter. It's not just in a vacuum.
No, but it's the First Tier Tribunal that is the primary decision maker. But I'll take you, the decision is at, the Secretary of State's decision is at page 119 of the bundle.
Yeah. And the relevant part is at 140, is it?
Yes, 140, yes.
So what the Secretary of State said was, first paragraph under that heading,
Yes.
summarizes, and I know this is, I don't want to read it all out, and it's distressing to your client, but summarizes the extent of the culpable conduct.
Yes. I mean, the applicant, the appellant who said, I mean, he recognizes the findings
Yeah.
made below.
And then after dealing with character and conduct, he does go on to say we've considered and assessed any exceptional mitigating factors.
Yeah.
And it deals with his good work record. It deals with the fact that he contributes to 2 community associations at least, the Greater Dhaka Association and the Islamic Cultural Centre. It refers to the length of time, but it says they don't outweigh the deception.
Yeah.
So has the Secretary of State, if he were being assessed, he's satisfied the balancing exercise, has he?
Yeah. So no issue with the Secretary of State's decision.
Right. Well, so you don't chat. Just to be clear about this, you don't challenge, or do you challenge the Secretary of State's approach to this issue?
No, I don't, and I cannot, because it's not, of course, a judicial review claim. When the matter reached the First Tier Tribunal, the appellant provided further evidence, gave oral evidence. The judge assessed oral evidence and made new, fresh findings. The question for this court is whether the First Tier Tribunal has erred on a point of law, as opposed to whether the Secretary of State has made a legal error in the decision.
But were there any other factors on top of the ones that are set out in the decision letter? You said gave evidence to the FTT. If in fact it's further elaboration of the same matters, because there's quite a full list of 141, then even if that new evidence isn't referred to, if it's actually the same as the evidence that the Secretary of State considered.
Yes, but the question, I say this with respect, is whether the First Tier Tribunal made a legal error. So when I showed you Yasin and said that the decision maker must conduct a balancing exercise,
Yeah.
this is the judicial decision maker as opposed to the Secretary of State.
No, I understand that, but I'm just trying to understand the submission. Are you saying, well, I think I understand what you're saying, so maybe we shouldn't worry about it.
Can I just show you the First Tier Tribunal's decision and then explain what's wrong with that and what sort of factors the tribunal did not consider?
Yes.
So if you go to page, the decision starts at page 101
Yes.
and it's page 117.
Yes.
Paragraph 90, so a single paragraph, 2 sentences. And this is strictly orbital in the sense that the judge has said that, well, you don't fall for refusal under 3221A, but if I'm wrong about that, discretion should not be exercised in your favor. And then the reasoning is in a single sentence, that the appellant has associated himself with community groups and good causes, but false representations is a serious matter and goes materially to his character. And that's really the extent of the reasoning.
There's no reference in the tribunal's decision to the specific points in your client's favour.
No.
Beyond that sentence.
There isn't. So what the judge was required to do in my submission was to conduct a balancing exercise in 2 stages as mandated by Balajigari and Yasin. And to balance the deception against a range of circumstances that were obviously in the appellant's favor, not merely his association with community groups and good causes.
That's what I was trying to get at. The judge would have known how long he'd been in the United Kingdom and that there's no other criminal conviction. And the positive factors in his favour were the 2 cultural associations that the Secretary of State referred to. Was there anything else actually put to him? I've not seen any suggestion that there was anything put that hasn't been either implicitly or explicitly dealt with.
Yes. So deception on one hand.
Yeah.
Now, can I just identify in bullet points the matters on the other hand? The first matter on the other hand is the timing of the misconduct. Timing, which Lawrence Underhill says is relevant. And I, of course, recognize what Milady said. Timing, that the misconduct was in 2013. 2013, now in 2024, the decision was in 2022. So good 9 or 10 years ago.
2021. Oh, you mean this decision?
Yes, this was in 2021, 2022, I think. Yeah, 2022. So 9 years. That's the first matter. Secondly, the Secretary of State's delayed response to the 2013 application. The Secretary of State could have refused that application in 2013, did not decide that application for 5 years, and it was then varied to an application which was ultimately decided in 2021. So the Secretary took 8 years to make a decision on the application. Third, the length of the appellant's residence in the UK is 15 years. Fourth, the nature of the appellant's residence. The nature mean that his residence throughout was continuous and lawful. His character and conduct during the period of residence throughout. Positive contributions in the UK, this is what the judge has highlighted. Absence from Bangladesh for a very long time, and health issues. Well, this appellant had serious, had mental health issues.
I mean, what was the evidence of that before the FTT, and was it referred to by the FTT?
No, it was the evidence as to mental health was before the FTT, and just identify the evidence for you. So in relation to mental health, and yeah, so a ground on which I do not have permission is that the appellant had mental health issues and was a vulnerable witness, and the judge erred in not recognizing the appellant as a vulnerable witness. And if you wish to just see a summary of the evidence that was before the judge, it is at page 84 of the bundle as part of the grounds of appeal that were put to the Upper Tribunal, paragraph 10. So the evidence before the FTT included evidence from Dr. Rahman that the appellant had hypertension, mixed anxiety, depression, mixed anxiety, depressive disorder, and the appellant was on medication. The appellant does not win on that basis, I accept that. But these were all sort of matters that the First Tier Tribunal in my submission was obliged to balance against the deception.
You're not suggesting, are you, from that paragraph that this is why he engaged in the deception in 2013?
No.
This is a current recent thing that, with all the stress and so on, your client has had these mental health difficulties. It's a current factor, not a factor that explains the conduct.
Of course, yes.
As I read the FTT's decision, it was that this case fell into the category identified in paragraph 46 of Lord Justice Irwin's decision in Yassin. It was sufficient, so serious, the conduct, that the factors wasn't outweighed by the positive factors.
Well,
Is it your case that even if that was the court's view, tribunal's view, it should nonetheless have gone through a more detailed balancing exercise?
yes.
And therefore, the decision was wrong or irregular. Is that your case?
It's wrong in law. That the judge in the first year is not saying that the matter is so serious that all those matters are simply irrelevant. The judge is saying that the matter is serious and goes materially to his character. This is paragraph
It's a
90.
particularly serious matter.
It is particularly serious. It goes materially to his character. But nothing more than that. So this isn't the sort of case where a balancing exercise would be meaningless. It isn't that case, Mulhot. This is an appellant who has lived here for 15 years. I accept that he will have an uphill struggle, a difficult case to run. But this isn't a case where the outcome is inevitable. A person who has lived here for 15 years, absent from Bangladesh for 15 years, mental health issues, delay on part of the Secretary of State, continuous lawful residence, positive contributions in the UK, there is a possibility that one properly directed judge may come to a different conclusion. So if the court is persuaded that there isn't a proper balancing exercise in the First Tier Tribunal's decision, in my respective submission, remittal would be appropriate.
Do you want to look at how the Upper Tribunal dealt with this issue?
Yes.
This
So
is
the upper,
88, I think.
yes. Yes, so if you look at, no, it's page 73,
Yes.
it's really paragraph 47. The Upper Tribunal said that, made 2 points. The first is that the appellant had conceded that the appeal should be dismissed, and I've explained in my skeleton that there was certainly no such concession by the appellant at the Upper Tribunal. Paragraph 47. The judge says that the appellant had conceded that the appeal should be dismissed, even if it was only discretionary grounds of refusal to be applied. There was no concession before the Upper Tribunal. I'll explain what has happened in the First Tier Tribunal. And then the Upper Tribunal just quotes the single sentence from the First Tier Tribunal's decision. And said that, well,
That was
that's
adequate.
that's the end of it. Yes. So when I opened the case, I said that, well, it's difficult to have any sympathy with a person who seeks to deceive immigration authorities. There's no question about it. But this is a person who has lived here for 15 years, with all the factors that I have out.
But you must remember that he lived here for 15 years, having made an application which was fraudulent and which extended his previously.
Yes,
He's had the opportunity to live for 15 years quite blamelessly, making valuable contributions and not committing crimes. But he only had that opportunity because of the initial, as they see it, quite serious fraud about the company, about the accounts.
Yes, but the point that I'm seeking to make is that despite that deception and the very unattractive facts, if a person is being removed after 15 years of residence with all those points, in my respectful submission, he deserves a proper consideration of all these factors, a proper balancing exercise. And that's why I said that it's a good case to test the argument. He deserves a proper consideration. If he is being removed from this country, he deserves a proper balancing exercise. I recognize that on remittal, if the court is persuaded that there is an error of law, the appellant may have an uphill struggle. There must be a proper, in my respectful submission, a proper balancing exercise. Well, I said that there was no concession before the Upper Tribunal that the appeal is dismissed, but in fairness, I must take the court to paragraph 6 of the Upper Tribunal's decision, where the Upper Tribunal recorded what had happened at the First Tier Tribunal, and counsel who represented the appellant at the First Tier Tribunal accepted that if the appellant had used deception, then the Article 8 appeal would have to be dismissed. But that really, if there was a concession, that really was the extent of the concession. I mean, Article 8 is an entirely different matter, and I completely accept that if this was a sort of paradigm Article 8 claim, and then it's just very difficult to see why the public interest would not require the appellant's removal, because there is a strong public interest. The balancing exercise under Article 8 is of a completely different character, but that does not answer the appeal under the immigration rules.
Can I just, forgive me interrupting you again? I know it's difficult sometimes if we interrupt too much, but do you think, was this issue, this distinction that between the Article 8 concession and the 3225 issue, was that made clear before the Upper Tribunal?
Yes, I appeared before the Upper Tribunal. And that
does the Upper Tribunal judge allude to that distinction?
Not sure if there is.
I'm looking at paragraph 47.
Yes, so paragraph 47, where, well, I've made a point in my skeleton that it wasn't immediately clear from paragraphs 46 and 47 what the Upper Tribunal meant by conceded that the appeal should be dismissed. Of course, I made no such concession, and I can only assume that the judge had in mind the concession that was made before the First Tier Tribunal.
Yes.
And I do recall, my Lord, that the judge asked this question when I was making my submissions, that this is what Mr. Kenta, who appeared for the appellant, then said, and the response is that the concession, if any, was about the Article 8 claim, not in relation to paragraph 3225. But just looking at, Lord, if you're looking at paragraph 47, the judge really hasn't ruled against the appellant because of that concession. The judge essentially says that, well, there was adequate balancing exercise. That
Takes
really is
both points. He says, in addition to the
in addition to
concession,
that, yes.
in any event, the judge carried out a sufficient balancing exercise in the circumstances.
Yes, so the submission is that the balancing exercise wasn't sufficient, it was defective in law. This isn't a case where the outcome is inevitable, and remittal is appropriate. So just finally,
Yes.
the point that is made in the respondent's notice that, there was an adverse decision under paragraph 276B, Roman 2C. There was no appeal against it, and
Academic point, yeah.
the short answer to that point is in paragraph 91 of the First Tier Tribunal's decision, page 117 of the bundle. So if you look at paragraph 91, the judge says, for the same reasons, I also conclude that the appellant falls foul of the public good requirement in paragraph 276B. For the same reasons, the reasons the judge gave as to paragraph 3221A and paragraph 3225.
Or is he referring back to a particularly serious matter because of the false representations, the stuff that's immediately before paragraph 91? That's the first question, what is he referring to? And the second question is, what are you saying paragraph 276B2C requires? Because it talks about conduct and character. Is it still that weighed against the other matters, or is it sufficient if they say, I'm sorry, but I think this was so serious?
No.
The requirement's not met.
No, under 276B2C, just like paragraph 3225.
There's got to be the balancing.
Yes, there has to be balancing, consideration of undesirability by reference to the list of factors, character, conduct, age, length of residence, for example, and so
So what
on.
about the first question then? Is 91 referring back to what he's just said in 90?
Well, in my submission, for the same reasons, in my submission means all the reasons the judge has given earlier, as opposed to paragraph 90. But even if it's paragraph 90, I have made my submission as to why paragraph 90 is defective. If I'm wrong, the appeal is dismissed. If I'm right, then paragraph 91 would be unsustainable too. So it's not in my submission, it's not a freestanding ground for refusal. It is contingent upon the decision under paragraph 3225 of the immigration rules.
But it's been raised under respondent's notice.
Yes.
Can we just look at how that's done?
Yes.
57.
So the alleged error is academic because the appellant has not appealed against the FTT's finding that his application does not meet the requirement in paragraph 276B2C. That's how it is put. Now, when the First Tier Tribunal dismissed the appeal, it was an appeal to the Upper Tribunal. The focus, of course, was on the decision under paragraph 3221A and 3225. But may I just show you the grounds of appeal to the Upper Tribunal, just to show you how the point was
Going back to the beginning, I mean, the Secretary of State did decide quite separately, didn't he, that the requirements of 276B2C were not met. So there was a finding at page 140 about that. So was that appealed first to the First Tier Tribunal?
Yes, and the First Tier Tribunal considered that
Right, okay.
in paragraph 91. I think the Millennium Trend is saying that there was no appeal on that point to the
Against
Upper
the
Tribunal.
FTT's finding, okay, that's fine.
So that's the point that is being made. But can I just show you the grounds as to how the grounds were put to the Upper Tribunal? If you look at page 88 of the bundle, this is ground 6, paragraph 3225 of the immigration rules. So the appellant pleaded Balajigari and Yasin And then look at paragraph 42. The submission was that the first-tier tribunal's approach is unsustainable in the light of Balajigari in the scene. There's no proper exercise, and then you'll see a challenge not only to paragraph 90 but also to paragraph 91. Paragraph 91 being the 276.
That's what you meant by
Other,
suitability provisions.
yes. And
So
so-
strictly, it's an eligibility requirement, not a suitability requirement
Yes.
in Part 9. But you say, really, we all know what it meant. He wasn't suitable for being granted leave because of the deception.
Yes, and
You're saying it's
91 was.
implicit in that.
91 was expressly challenged. I mean, if the complaint is that there should have been a separate heading, and the appellant should have just repeated the points made earlier, then that isn't a good point.
In Yassin, there had there been an issue under 276B2C?
Yes, that was a long residence application. That was a case about 276B2C and its interplay with paragraph 3225 of the immigration rules, whereas Balajigari was only paragraph 3225.
So when you referred in the shorthand way that you did in paragraph 42, to there being no two-stage balancing standards required by Balajigari and Yassin, you say that also encompassed the 276B2.
Yes.
But oddly, in your grounds of appeal to this court, you don't appeal against the Upper Tribunal's dismissal of the appeal against the 276B finding. Your grounds 5 and 6, 17, are focused solely by reference to 3221A and 3225.
Yes, there is a reason for that, which is in the Upper Tribunal's decision, paragraph 48.
Yeah.
So you'll see that the Upper Tribunal did not read the refusal under paragraph 276B as a freestanding or a distinct reason for ground for refusal. Paragraph 48, the judge says that the judge in the first year said that for the same reason, he concluded that the appellant fell foul of the character and conduct and association requirement.
Yeah, he
Can
found,
carry on, para 49. So the judge gave
Adequate
adequate
reasons.
reasons for the findings which he made. And I read that to say that paragraph 91 was an adequate balancing exercise. You
Paragraph
have to
91.
challenge that.
Paragraph 91 was an adequate
Yeah,
exercise.
I read paragraph 49 of the Upper Tribunal to be saying that the balancing whatever the FTT judge did at 91 of the FTT, reference paragraph 48 of the Upper Tribunal, that was adequate.
Yes, but
So that needed to be challenged, didn't it, in this court, if you wanted to bring that in?
yes, can I just quickly just look at the original skeleton? Yes, so if you look at page 45 of the bundle,
What's this? This is the
the permission skeleton argument, permission to appeal skeleton argument, where this ground 6 was developed.
Well, should we just do, is it worth just to get a clear sight to look at the grounds of appeal
Yeah.
and just check on page 17, because that's what comes in first, there's no reference there to para 276B2C.
No, there isn't. No.
Okay, and then you take us to
The
skeletons.
reason being, as I submitted,
Yeah.
this isn't a sort of freestanding ground in my respective submission.
but it is according to the respondent, because if you don't meet the eligibility requirements, it doesn't really matter whether you've been refused under Part 9.
Put it in this way, that if the appellant fails under paragraph 3225 of the immigration rules, there is no way the appellant can succeed under 276B. But if the appellant succeeds under paragraph 3225, there is simply no way the Secretary of State can refuse him under paragraph 276B2.
He has, and you haven't appealed it at the moment. I mean, page 45 follows on from ground 6, paragraph 3225 of the immigration rules, and you identify the error of law as being the 3225.
So you're reading, I'm so sorry.
Page 44 and 45. You took us to 45
Yes.
of your skeleton. paragraph 67 and talks about GZ, but the context is after paragraph 65 in the heading, ground 6, paragraph 3325. Then you identify the error of law, and that's 3225.
Yes, but if you look at paragraph 68, 68, my lord, at page 45, referred to Yasin and said that the First Tier Tribunal found that false representations were made. I referred to paragraphs 90 and 91. 91 is about 276B, and said that there wasn't any two-stage balancing exercise as mandated by Balaji Gari and Yasin. And because, yes, so that is, in my respective submission, is a challenge to paragraphs 90 and 91. So to both paragraphs. 90 deals with paragraph 3225, and 91 deals with paragraph 276B. I mean, if the criticism is that there should have been more submissions, then what one must consider that criticism in context that 91 is really a single sentence. The judge says that, well, for the same reasons, I'm also making the decision under Rule 276B.
I think what's being suggested to you is that this should be first and foremost a ground of appeal, and
To this court.
and that if it was a ground of appeal, there's an argument put forward. You say that other suitability provisions is sufficient. Given that the issues are identical, you say, between 3225 and 276 B2, that you wouldn't need to develop it. And this would be, but it isn't a ground of appeal.
Yes, it's essentially, yes, it is in my submission that the same point.
It's not a ground of appeal.
But it's not a ground of appeal. It may be the same argument, but it's under a different heading, and you'd have to apply, and you would say there'd be no prejudice in applying now to add 6A or 6B, whatever you want to call it. Also wrong under 276B for the same reason.
Have you completed your submissions about from this point?
I have, yes.
We're going to rise just a couple of minutes just to take stock, and maybe you and your junior would like to reflect if there's any other application or matter you'd like to put before us.
Yes, good.
Thank you very much.
Well, why, if you're able to.
Just letting you know that the live streaming will continue because it's only rising for a few minutes.
It's fine. Cause any prejudice. Hi, how are you? Yeah, okay, good to see you. Yeah, I can come back. Yes, yes, they do. Yeah. Yeah, the same application.
Use the word withdrawn,
Withdrawn, yeah.
but is not the consequence of extending 3C leave.
Yes, yes, yes.
Why? Maybe the Citizenship Act as well, like have a decision for planning in the Citizenship Act, International Act, the good guys, they discount it, they don't count it.
Yeah, yeah, they have the form. Let's see if it says anything about the application. Sorry, it took longer than I
No, that's
expected.
okay.
I think I thought I would finish by lunch, but let's see.
It might not be too long. Let's see how they go.
Want me to make an application to amend the grounds, I'll make that application just to add,
Are you going to?
yes, I think, yeah,
Okay.
just to add the words paragraph 276B2 as well in ground 5.
Okay.
Council, are we all ready? Court rise if you're able to.
Yes.
I'm very grateful for the opportunity. May I respectfully take the court to page 17 of the bundle? So pages 16 and 17 are the grounds of appeal. So ground 6, page 17. So may I respectfully seek the court's permission to amend that ground, so to insert the word paragraph 276B2 immediately after paragraph 3225.
And paragraph.
And paragraph 3276, yes.
Okay.
There's no prejudice to the Secretary of State. The point was developed in the skeleton argument. And both the First Tier Tribunal and the Upper Tribunal took the view that the reason why the appeal was dismissed under 276B2 is because of the reasons given in relation to paragraph 3225. Very grateful.
Thank you. All right. Anything else you want to say?
Very grateful. Thank you. So unless I can assist you any further.
No, thank you. Thank you very much. Ms. Pottle.
My lord. Yes. My lords, my lady, the issues in this appeal are narrow.
Sorry.
Pardon me, I have a cold.
Oh, I'm so sorry.
You have a cold. There's air conditioning or heating. Do you want to come forward a row? I don't think Mr.
Yes, I think I will.
All right. You want to bring all your bits and pieces forward as well? Don't forget your water. Just so you know, Miss Pottle, while you're rearranging things, we're going to rise at 10 to 1
Yes.
for a slightly longer adjournment. Yes?
Yes. My lord, I must confess, many of the submissions that I had planned to make have already been covered in some detail this morning during my learned friend's submissions, and there were questions put to him. So I propose to go through briefly the issues and my responses, but please do interrupt me if there's anything in particular that I can assist you with, and move me on if there's something that...
Well, obviously, as you'd expect, we have drawn on your submissions in testing Mr. Malek's arguments.
Yes.
But nonetheless, we'd like to hear how you put the case.
Yes, of course. And so, the issues in the appeal in my submission are three distinct issues. Firstly, whether the appeal is academic. Secondly, whether the First Tier Tribunal and the Upper Tribunal were correct in their analysis that the application fell to be determined as against paragraph 3221A. And if not, whether they were correct in holding that the application fell to be refused as against paragraph 3225 of the rules in any event.
Yes.
If I can begin by going through the facts, beginning with the refusal letter, which is the Secretary of State's decision, which appears at page 120 of the bundle.
Yes.
My lord will see, of course, that the refusal was made as against paragraph 276B2 and 3, and paragraph 3221A and 3225 of the immigration rules.
Yes.
If I can direct the court in particular to page 141.
Yeah. Well, 140 and 141 is where we have the 3225 analysis. Yes.
If the court looks at 141 in particular,
Yep.
this is the analysis under 276B2 little c.
Yeah. So you're right. 3225 is on 140, and then it leads into 276.
Yes, that's right. The Secretary of State refers to the response, and just by way of background, this is a case in which the Secretary of State, of course, wrote to the appellant, setting out the allegations of dishonesty, and the appellant responded with a long letter. And this quite long refusal letter sets out a detailed consideration of the reasons put forward, both as against the dishonesty, but here as against the wider factors of conduct, if I can put it that way.
Yeah.
So here, the Secretary of State says that your response confirms that you've been working for a reputable company for more than 10 years and paying national insurance and tax. Notes that he has not been involved in any other criminal activities, and he has a driving license. Notes his association with good causes, pandemic, and notes the length of time that he's resided in the UK lawfully under Section 3C. It says in the final paragraph, the Secretary of State notes your circumstances have been considered carefully and the positive contributions you've made are admirable. However, we are satisfied that based on the information you have provided, there are no such exceptional circumstances that outweigh the deception involved in the submission of a non-genuine financial transaction, business agreements in support of your application. And I draw that to my Lord's attention because it is a relatively detailed consideration of all the factors that my Lord points to in his submissions on whether the error is material. And I'll come to those submissions in due course, but wanted the court to note here the first consideration. Then moving on to the decision of the First Tier Tribunal, if I can draw the court's attention to page 116. Although I should first note, that in paragraph 4 of the decision, the judge references, paragraph 4, he says, I do not seek to do injustice to the extensive detail relied upon by the decision maker, but for the purposes of this judgment, I will seek to summarize the cases made by the Secretary of State.
Yes.
So the judge does make explicit reference.
He alludes to it.
Yes, exactly. That
And
he's-
says because it's known to the parties or something like that. All of which is known. Let me get the words.
Yes, it's at paragraph 4, which is
That's
at
right.
page 102.
Bearing in mind both parties are aware,
Yes.
etc. There's a little footnote referring to a decision of this court. Yes.
Yes, and so then if I can take the court next to paragraph 79.
Mhm.
These are the findings of the judge in relation to the dishonest, the false representations. He says that by the 16th of January, the appellant did know that the application was being made, that the application being made contained false representations, or in the alternative, despite signing the declaration in the form, he had not seen the supporting documents, which is itself a direct false representation.
So it's either he knew, or if he didn't know, by signing the form saying "I know" when he hadn't signed them. The false declaration was this claim that he knew when he didn't know. Is that right?
Yes,
Ah,
yes,
yeah.
precisely, my lord. And the judge finds that it's more likely than not that he decided to ignore what was going on in the hope that he would receive his leave extension, and that any potential difficulties in the future would be seen as the fault of immigration for you and not directed at him. And I should have, forgive me for jumping around, I've also drawn my lord's and my lady's attention to paragraph 5 of the judgment. Yes, of the judgment at page 102 of the bundle, which sets out a bit more a summary of the fraud perpetrated by immigration for you. So as a consequence of Operation Meeker, 6 people were convicted of falsely creating businesses in order to assist individuals in applying for leave to remain, as well as cheating the public revenue by claiming tax rebates on the false earnings created by a number of money loops. And this sophisticated fraud was carried out during the course of some 5 years. And of course, this is the firm that the appellant had used to submit his application. So it is quite a serious and sophisticated fraud. Turning then to the rest of the decision, I wanted to draw my lord's and my lady's attentions to paragraphs 84 to 86. 84 deals with the section, the Rule 3221A, and the judge finds that the relevant rule is Rule 3221A on the basis of the decision of the Court of Appeal in JH, but there is only one application at any one time until it is decided. And the respondent's position is that the judge was correct in his analysis on that point. And I will take you to that decision in due course. And the judge noted that, so the application remained that as originally made in 2013 and eventually varied. So the Secretary of State was right to find that the false representation had been made in the context of the application because it was, in law, the same application. The judge is then finds further support for that interpretation in paragraph 88, considering Rule 3222, which he says could not apply in this case. And that rule is that the making of false representations for the purpose of obtaining a previous variation of leave. In my respectful submission, the judge was right in deriving support for his interpretation, because of course, in this case, 3222 could not have applied because the applicant had not obtained a previous variation of leave. And so the only, or the option into which the case obviously fell was 3221A. And then, of course, as my lord and my lady have noted, at paragraph 90, the judge then considers the alternatives.
Sorry, before you leave 88 and 89, what Mr.
Yes.
Malik submitted was that this is a mistake. It's not right to say it can't fall into 322, and therefore, if it goes anywhere, it goes into 3221A, because 3222 submitted Mr. Malik was that you were to make false representations for the purpose of obtaining leave. Might not succeed, you might be rumbled. So the fact that it didn't lead to the grant of leave, says Mr. Malik, is not the key thing. It's the purpose for which you make the false representation.
Well, in my submission, that can't be correct because there are a number of alternatives.
Mhm.
So one alternative is for the purpose of obtaining leave to enter, which
Yes,
is not the appellant's case because he was already here.
yes.
So for him, the relevant section was for the purpose of obtaining a previous variation of leave. So we can cross out leave to enter because it's obviously not relevant to him. The relevant option is a previous variation.
And the previous variation is on any analysis, the ones he had before 2013.
Well, yes, because those are the only ones that he obtained.
Are you going to take us to the authorities?
Yes, yes, I am.
Because you make some submissions, which we alluded to this morning, about JH and Khan.
Yes, I am going to take my lords and my ladies.
Yes. So developing the points in your submission, in your skeleton at on page 53, I think.
And so then at paragraph 90 and 91,
Yes.
the judge then considers the alternative case.
Yes.
Which I will deal with when I come to my submissions under the sixth ground of appeal.
Yeah.
Then if I can deal very briefly with the Upper Tribunal's decision.
Yes.
Page 73. So the relevant section is really quite short. It's just paragraphs 44 to 49.
Yes. Well, on ground 5 point, it's really 44, and then 45, which, as Mr. Malik conceded, was the not the relevant version of the rules, or
Yes.
relevant, not the version in force at the time of the application.
Yes, that's right. I should add that noting that the appellant disputes that the concession referred to by the judge was made, there is an argument about whether the concession extended as far as the Upper Tribunal held that it did. The respondent's position, as set out in the skeleton, is that the decision of the First Tier Tribunal records a concession dealing with Article 8, and in those circumstances, we don't argue that the appellant should be held to this wider concession that the Upper Tribunal seems to think was operating at the time. So we're not.
So this is paragraph 46.
Yes.
So you accept, do you? How would you put it?
Well, it seems that at 46 that the Upper Tribunal judge is referring to a concession. So he says that I do not consider that there was a material error where it's not in dispute that the other suitability provisions were engaged, and it was agreed that if deception was made out, the appellant's appeal fell to be dismissed. So that's the sort of crucial part of the concession. The Upper Tribunal judge thinks that because of course at that time the appeal was also in relation to the burden of proof and whether the deception had been made out. The judge was operating on the presumption that it had been conceded that if deception was made out, then the appellant's appeal fell to be dismissed. And my learned friend has, in his skeleton as well, said that that was not the concession made before the Upper Tribunal.
I read paragraph 46 as being much simpler. It's saying it's too difficult for me to decide whether this is 321A or 3225 or 276BC2. It's definitely one of them. And therefore, so long as the FTT has gone right on any one of those, and he takes in the next paragraph 276B and 3225, the decision is okay. So I don't know that he's reaching a conclusion, is he, about whether it's 3221A or 3225. And on your submission, and one might say as a matter of logic, it's either one or the other. It can't be both a mandatory and a discretionary refusal.
Yes, that's right. It has to be one or the other. Well, I simply wanted to make the point that the respondent's not holding the appellant to the concession that seems to be referred to there. And one final point, just at this stage, is that the quoted text of paragraph 34BB here is, of course, is not the version that was in force when the decision was taken. I think my learned friend and I'm not sure that we're quite agreed, but the respondent's position is that the versions, generally speaking, the relevant version is the version which is in place when the decision is taken. That's the usual position. House of Lords authority to that effect, unless there are transitional arrangements in place which dictate that a particular rule won't come into force unless an application is made after a certain date. In this case, I don't think anything turns on the issue because Rule 34BB didn't change between when the application was made and when it was decided. And the version that you have in the bundle is the version which was relevant at the time. The version which is in place now, I know my learned friend has drawn your attention to it this morning, but in my submission it's not really relevant to the issues that this court has to decide.
For instance, if it does turn on that, that means that 3221A has changed its meaning, because if it had one meaning having regard to the old version, but the new version was critical, that would be a rather odd way of bringing about a change in the meaning of 3221A, because that's the rule. It's what the word application, or in relation to the application, means in that rule that we're dealing with.
Yes, and the court should be looking at the rules as they were at the time that the decision is taken, both 322A and the surrounding rules if necessary, if that provides some assistance. The only other point to make, and as was noted by the judge in the First Tier Tribunal, is that Part 9, of which 3221A is a part, because of transitional arrangements, it's actually the old version which was in force at the time the decision was taken.
As far as 322 is concerned, that only applies to applications made, I thought, after the 1st of December 2020, and this was made before then, so it was made November. Is that right?
Yes. So, yes, it's set out in the judgment itself, but the old part applied to any decisions which were made before, yes, December 2020. That's right. And so that those are the points I wanted to make in general on the decisions and the facts. Now, my lord, I don't know if now.
You're going to now embark upon the interpretation of 3221A in the light of the reported authorities and other matters.
Yes, that's right.
Now, it's going to take you more than 2 minutes.
I think so.
So I think we'll rise now. And we resume at 2:05.
All right, you able to?